Chapter 24. Injunction against Nuisance. Analysis. Section 1926. Section 512. Nature and extent of the jurisdiction. The term nuisance has in equity no different signification from that given it in law. Anything which is a nuisance in law is also a nuisance in equity, and, on the other hand, it is true that equity will only interfere, in case of nuisance, where the thing complained of is a nuisance at law. There is no such thing as an equitable nuisance. This is not saying that the jurisdiction of law and that of equity are coextensive, it is simply pointing out that equity in the determination of what constitutes a nuisance follows the law. Whether, assuming a nuisance to exist, equity will take jurisdiction to enjoin it, is another question, a question which is answered in every particular case by determining whether there is a need of equity interposing, whether, in the usual phrase, the legal remedy is adequate. No special attention need, therefore, be given here to a definition of nuisance, though such of its characteristics as affect the equitable remedy will be spoken of in connection with those features of the equitable remedy to which they are related. Section 1927. Section 513. When the legal remedy is adequate. While the jurisdiction of law over nuisance and that of equity are not coextensive, much more nearly than in cases of trespass, it is true that every person injured by a nuisance may come into law or equity, whichever he prefers, for his remedy. The reason for this is, that from their nature and effect, most nuisances cannot be satisfactorily remedied at law. The grounds on which equity enjoins nuisances are chiefly, two, viz., irreparable injury to plaintiff, and the prevention of multiplicity of suits. Those which will not be enjoined, therefore, are such nuisances only as do not fall within either of the above classes. But this necessarily means a comparatively small number of cases, for it is characteristic of nuisances in general that they are either continuous or recurring, or else they cause irreparable injury, and in many cases, indeed, they are of a character to bring them within both of the reasons for equity's intervention. It is said in one case, it is not in every case of nuisance that this court should interfere. I think that it ought not to do so in cases in which the injury is merely temporary and trifling, but I think that it ought to do so in cases in which the injury is permanent and serious. The language of another court is that nuisances which are temporary and occasional only, are not grounds for the interference of this court by injunction, except in extreme cases. These two extracts taken together probably contain a complete statement of the kinds of nuisances for which the legal remedy is considered adequate. They are, 1. Nuisances which are temporary and single and which do not cause irreparable injury. 2. Nuisances which, not doing irreparable injury, are yet repeated, but only occasionally, not so often that the suits at law to redress them cause a vexatious or oppressive amount of litigation. Section 1928. Section 514. Extent of the jurisdiction, irreparable on continuing or recurring nuisances. In the preceding paragraph it is said that the chief forms in which the inadequacy of the common law, the fundamental basis of all equity jurisdiction over tort, manifests itself, are cases of irreparable injury, and cases of continuous or repeated nuisances involving a multiplicity of suits at law. These two grounds of jurisdiction do not readily, if at all, admit of separate treatment. However, the definitions of nuisance very generally agree in including as one of its elements that it is something which interferes with one's comfort in, or enjoyment of, his property, and it is the loss of this comfort and enjoyment in the use of his property which gives the right of action. Now comfort and enjoyment are almost ideal illustrations of the sort of thing for the permanent loss of which damages will not be a fair and just compensation. They are not to be paid for in money. They are in this respect essentially of the same character as the paritium affectionis which the courts sometimes have made the basis for decreeing specific performance of contracts to sell chattels, or for injunctions against trespasses to chattels. Hence it follows that most nuisances when permanent, or when continuing for any considerable length of time, or when frequently repeated, are properly to be classed as irreparable in their nature. Besides this feature of nuisance, which pertains only to its effect on the person injured, it is to be remembered that the property affected is usually land, which is regarded as peculiarly within the protection of equity, and so far as one's enjoyment of his land is destroyed, it is a destruction, if not physical, yet at least in the character in which it has been held and enjoyed, of what is generally regarded in equity as property so peculiar as not properly to be made a subject of compensation by a jury. In brief, then, a continuing nuisance is in general an irreparable injury, for two distinct reasons: 1. From its effect on the person injured; 2. From the destructive nature of the injury to the use of property of a peculiar character. But in both the above reasons the fact that the nuisance is permanent or continuous or repeated is a very important, if not essential, element, and, as most nuisances are pertinent or continuous, or repeated, this fact alone is enough to bring them into equity. Hence it has not been necessary for the courts to attempt careful definitions of irreparable injury in nuisance cases, as a more obvious and simple ground of jurisdiction is usually ready at hand. And the fact that the studied care of the meaning of the term, which is common in the cases on trespass, is largely wanting in the cases on nuisance, may be perhaps thus explained. This may also explain the frequent practice of the equity courts in nuisance cases to confine their attention to the question of fact whether a nuisance exists or not, and to assume jurisdiction as a matter of course. Both of the above suggestions are borne out by the following language of the court in a well-considered American case. The next position taken in behalf of the defendant is, that even if the subtraction of this water is to be held to be wrongful with respect to the complainant, still a court of equity will not give relief by way of injunction, but will leave the parties injured to their remedy at law. If this were an application for a preliminary injunction, it is clear that an objection of this kind should prevail, for the act which the defendant threatens to do is obviously not of a character to inflict any irreparable injury. But after a court of equity has entertained a bill, and, instead of sending the case to a trial at law, has itself tried the questions of fact involved, and settled the legal right in favor of the complainant, it certainly would be a result much to be deprecated, if, at such a stage of the controversy, it was the law that the Chancellor were required to say to such a complainant, "Your right is clear, if you sue at law you must inevitably recover," and after several recoveries it will then be the duty of this court, on the ground of avoiding a multiplicity of suits, to enjoin the continuance of this nuisance. Still you must go through the form of bringing such suits, before this court of equity can or will interfere. In those cases in which to the mind of the Chancellor, the right of the complainant is clear, and the damage sustained by him is substantial, so that his right to recover damages at law is indisputable, and the Chancellor has considered and established his right, I think it not possible that any authority can be produced which sustains the doctrine contended for by the counsel of the defendant. Section 1929. Section 515, Illustrations. The cases in which nuisances were enjoined were not frequent before the middle of the last century, but since that time they have become very numerous, covering a wide variety of states of fact. Illustrations are injunctions against the pollution, diversion, obstruction, or abstraction of running water. The pollution, taking, or waste of percolating water, noises of various kinds, vibration from machinery or from pounding, unpleasant odors from urinals, privies, horses, stables, slaughterhouses, and the like, noxious vapors, gases or smoke from brick kilns, factories, blacksmith shops and the like, objects or acts which are dangerous to those in their vicinity, such as powder magazines, hospitals for contagious diseases, blasting and similar dangers, things which offend the moral sense, such as brothels, obstruction of highways or navigation, removal of support to land, acts which cause a physical invasion of the plaintiff's land, such as overflowing it, or casting refuse matter upon it. This list is not designed to be an exhaustive classification from the nature of nuisance. No list could be exhaustive, but it will serve to show the more common forms of nuisances which have been enjoined and something of the extent of equity jurisdiction of the subject. Section 1930. Section 516. Injunctions on sole ground of preventing multiplicity of suits. In the cases in which the only reason of equity's intervention to enjoin has been to prevent the necessity of a multiplicity of suits at law because of a continuing or recurring nuisance, the courts have shown the same lack of unanimity that is always common to this ground of jurisdiction, whether it arises from a trespass, nuisance or other tort. Consonant to principle, the weight of authority holds that the mere existence of a continuing or recurring nuisance, however trivial, provided only it is sufficient to sustain an action at law for damages, will support a bill for an injunction. There are authorities, however, which hold that this is not enough to base an injunction upon, and that the only multiplicity of suits which equity will interfere to prevent is that in which there are a number of parties to the controversy on one side or the other. It may be added further, though the matter calls for no discussion in this place, that the subject of nuisance is the most fruitful field in furnishing the questions of greatest difficulty under the head of bills of peace, viz., questions as to the propriety of joining as plaintiffs or defendants parties between whom there is no community of interest in the subject matter of the suit. Section 1931. Section 517. Miscellaneous grounds of jurisdiction. It has already been pointed out in these pages that the fundamental reason for equities enjoining nuisances is the lack of an adequate legal remedy. It has also been seen that the most common illustrations of inadequacy are the cases in which the injury is irreparable or of a continuing or recurring nature, and that these two grounds of jurisdiction are usually found together in the same cases. This is so largely true that almost all of the cases are rested on one or both of these grounds. The few cases that remain are, perhaps, on this account, the more significant in demonstrating that the fundamental reason, the inadequacy of the legal remedy, is not to be reduced to a few or any specific number of forms of manifestation. It is an open inquiry in every case whether the plaintiff can get adequate relief at law. If not, for any reason, he may come into equity. Here, as elsewhere, it is not enough that there is a remedy at law, it must be plain and adequate, or, in other words, as practical and efficient to the ends of justice and its prompt administration as the remedy in equity. Hence inadequacy has been found in the fact that independent acts of several defendants combine to produce the injury to the plaintiff so that the particular share of damage done by each one is incapable of ascertainment. This reason may apply equally to different states of facts whenever, for any cause, the amount of damage is unascertainable. Its substance is simply the obvious proposition that whenever the estimate of damage is recoverable at law must be based largely, or to any considerable degree, upon conjecture, the legal remedy cannot be adequate. Other unusual reasons for granting injunctions have been, in a bill to enjoin the obstruction of a public street by municipal officers, that the social standing, and character and reputation, of the defendants would make indictment ineffectual, while abatement would not be an adequate remedy because the expense of abating would fall on the taxpayers, and, in a bill by a tenant to have a bridge, which obstructed the entrance to the building he occupied, removed, that the plaintiff's legal remedy was inadequate because he, being a tenant and not owner of the fee, could not maintain an action for abatement but could sue only in case for damages. No case has been found so holding, but it would seem clear that the insolvency of a defendant might well be a basis of injunction here, just as, by the weight of authority, it is in trespass. As in trespass, too, the basis of an injunction is sometimes said to be that otherwise the defendant would acquire a prescriptive right to do the wrongful act. Section 1932. Section 518. What the plaintiff must allege. A plaintiff who seeks an injunction against a nuisance must allege his own right clearly and definitely in order that the court's order for the protection of it may be certain and without ambiguity. Otherwise the decree will, of course, be impossible of intelligent enforcement. He must also, for obvious reasons, allege that the defendant is doing or threatening to do the acts complained of. It is not necessary for the plaintiff to allege that his injury will be irreparable or that the legal remedy is otherwise inadequate, as that is a mere conclusion of law. He must, however, allege facts which will show the injury to himself and the inadequacy of his legal remedy. And in the courts of the United States, at least, this inadequacy is regarded as so important, that it may be insisted on by the court sua sponte, though not raised by the pleadings, nor suggested by counsel. Section 1933. Section 519. Previous trial at law. Since the rights that are involved in cases of nuisance are purely legal, equity taking jurisdiction in particular cases only to furnish a more perfect remedy than the law affords, and following the legal rules in the determination of all questions save the adequacy of the legal remedy, it follows that a problem of procedure may be presented to the equity courts when an injunction is sought by a plaintiff in whose favor the legal right, or the fact that a nuisance exists, has never been determined. In such case, Should the Court of Equity pass on the questions of law or fact raised? Or should it refuse its extraordinary relief until the plaintiff has procured a judgment of a court of law in his favor? Section 1934. Section 520. Not necessary to granting of temporary injunctions. The scope of the inquiry may be narrowed by first pointing out the classes of cases in which, though there has been no trial at law, the above problem is not raised. Chief among these is that class of cases in which only a temporary injunction is sought. The purpose of a temporary injunction generally is to keep matters in statu quo while some disputed question of law or fact is being settled. Obviously, granting or refusing it cannot turn upon the settlement of the question, either in law or equity. It has its own rules, which will be considered later, but this is not one of them. The Supreme Court of the United States in a comparatively early case on this subject said, "The true distinction in this class of cases is that, in prospect of irremediable injury by what is apparently a nuisance, a temporary or preliminary injunction may at once issue. But not a permanent or perpetual one till the title, if disputed, is settled at law." And the law is clearly in accord with so much of this distinction as pertains to the granting of temporary injunctions. Section 1935. Section 521. Nor in all cases of permanent injunctions. There are, also, some cases in which a permanent injunction is sought, where the objection that the plaintiff has not obtained a judgment at law should be disregarded wholly by a court of equity. The first of these is the case in which the defendant does not dispute either the plaintiff's right or the fact that a nuisance exists. To insist on a trial at law in such case would be to impose needless hardship on both parties to the suit. The only object in establishing title at law is to show that the right is in the plaintiff. The suit at law is only a means to accomplish a given end. When the end is already obtained, there could be no reason for doing an idle thing. This, the law, as a rational system, never requires to be done. If the title of the plaintiff be conceded, then there can be no need of a trial at law to establish that which is already admitted, and the reasoning is, of course, the same as to an admission that a nuisance exists. Hence the courts are agreed that no judgment or verdict at law is necessary in such cases. On the same reasoning it is held that a plaintiff's bill is not demurrable for failing to state a previous trial at law. By demurring, the defendant admits the plaintiff's right and the fact of an existing nuisance. In the next place, a trial at law will not be required when, from the evidence at the hearing, the controverted questions are clear in favor of one or the other party to the suit. Here, too, a trial at law would be superfluous. It is on this ground that courts proceed when they hold that a mere denial of the complainant's rights by the defendant in his answer will not oust the court of its jurisdiction by injunction, or that a party who has been for a long time in the undisputed possession of the property or enjoyment of the right with respect to which he complains, may procure an injunction in spite of such denial. And, finally, if both parties consent or request that the equity court try the merits of the disputed question, it will do so, and it has been held that an objection to this course of proceeding cannot be taken if it has not been raised by the answer. Section 1936. Section 522. Cases in which it is important. The class of cases not yet discussed is that in which on application for a permanent injunction, the plaintiff's right, or the fact that a nuisance exists, is doubtful on the evidence before the court, and the parties do not consent to have the controversy settled by the Court of Equity. In this situation the general doctrine is that either party is entitled to insist that the questions on which the legal rights depend should be tried at law. Satisfactory grounds to support this rule as a matter of reason are not to be found in the cases. Doubtless the explanation of it is largely the fact that in early days the courts of equity were reluctant to undertake the decision of purely legal rights, or questions of fact which ordinarily were tried by a jury. It was a rule of expediency and policy, rather than an essential condition and basis of the equitable jurisdiction. As such, the grounds on which it arose have largely, if not quite, disappeared with the decay of all hostility of the courts of law against the equity courts and the general merging of both law and equity functions in the same courts. The rule, however, still persists in most jurisdictions in which it has not been abrogated by statute. It has never gone so far, however, as to require the plaintiff's bill to be dismissed because the legal questions had not been determined, the court may retain the bill and procure ascertainment by directing an issue, or an action, or a case stated, at law, basing its final decree upon the results thus reached. In leaving the subject, it should be noted that when the bill is to enjoin a threatened, as distinguished from an existing, nuisance, from the nature of the case the requirement of a previous trial at law cannot be applied. No such question in this case can be tried at law. No nuisance exists. The object of the bill is to enjoin the defendant from creating one. From the foregoing discussion it would appear that the following is an accurate summary of the general rules of equity with respect to the requirement of a previous establishment of the plaintiff's right at law. The requirement does not apply at all to applications for temporary injunctions, nor to bills for permanent injunctions on account of irreparable injury, when the defendant admits the plaintiff's right, or when the right is clear in favor of one of the parties, though disputed, or when both parties consent to a trial of the merits by the equity court, nor to bills for permanent injunctions against threatened, as distinguished from existing, nuisances. It does apply to all other bills for permanent injunctions, but there is a tendency to do away with the requirement by statute or judicial innovation. Section 1937. Section 523, Threatened Nuisances. Imminent danger. In one sense all injunctions against nuisances are injunctions against threatened nuisances. The only purpose of giving equitable relief at all is the prevention of future harm, but this harm, being future, cannot be a matter of absolute certainty and therefore is only threatened. If, however, at the time the bill is filed a nuisance is actually being committed, there will, in general, be no question that the threatened danger is sufficiently made out to justify an injunction, if the case, in its other aspects, is sufficient. But when the nuisance has not yet come into existence and the plaintiff, therefore, must make out his case of apprehended danger by other means than by pointing to an existing nuisance, a question may be raised concerning the rules by which the court is to be guided. What is believed to be a proper statement of these rules was thus formulated in a leading English case: there must, if no actual damage is proved, be proof of imminent danger, and there must also be proof that the apprehended statement will, if it comes, be very substantial. I should almost say, it must be proved that it will be irreparable. Because, if the danger is not proved to be so imminent that no one can doubt that, if the remedy is delayed, the damage will be suffered, I think it must be shown that, if the damage does occur at any time, it will come in such a way and under such circumstances that it will be impossible for the plaintiff to protect himself against it if relief is denied to him in a quiet action. In a word, the threatened danger must be imminent, and of a character to do irreparable injury. In a bill to enjoin the erection of an engine to pump water into a river which the plaintiffs were cleansing and improving, the court discussed the nature of an imminent danger as follows: if, indeed, this be a work which not only gives the power of doing mischief, but cannot be used or can hardly, in the common course of things, be used without working mischief, if, in short, it be a thing which can hardly be used without being abused, the case comes to be very different. For, in matters of this description, the law cannot make overnice distinctions, and refuse the relief merely because there is a bare possibility that the evil may be avoided. Proceeding upon practical views of human affairs, the law will guard against risks which are so imminent that no prudent person would incur them, although they do not amount to absolute certainty of damage. Nay, it will go further, according to the same practical and rational view, and, balancing the magnitude of the evil against the chances of its occurrence, it will even provide against a somewhat less imminent probability in cases where the mischief, should it be done, would be vast and overwhelming. Accordingly, if it appeared that the works in question could hardly be used without damage to the inferior districts, I might hold that erecting them was, in itself, a beginning of injury, though there might be a possibility of otherwise using them, and if the damage, should it happen at all, were the destruction and the subjecting of the lower districts to a deluge, I might scrutinize less narrowly the probability of the engines being injuriously worked. This passage states and illustrates clearly the principles which guide the courts in this matter. On the one hand, a mere possibility of a future nuisance will not support an injunction, it must be probable. On the other hand, the plaintiff, who, of course, has the burden of proofs does not need to establish this probability by proof amounting to virtual certainty that the nuisance will occur, nor even proof which establishes it beyond a reasonable doubt. It is sufficient if he show that the risk of its happening is greater than a reasonable man would incur. And the balance between these two rules will be affected by the seriousness of the nuisance feared, the strength required for the plaintiff's proof diminishing somewhat as the greatness of the apprehended damage increases. Section 1938. Section 524, Illustrations. In accordance with these rules, it is held that a thing which may or may not be a nuisance, according to the way it is managed or controlled when in use, will not be enjoined. The plaintiff, by showing only the intended construction or use of the thing complained of, does not meet the burden of proof that is on him, the presumption being that a person entering into a legitimate business will conduct it in a proper way so that it will not constitute a nuisance. Hence injunctions have been refused against the erection of a stable, or a planing mill, or a cotton gin, or a jail or a coal chute, the building of a dam, or an embankment, the opening of a gas well, the establishment of a private burial ground, the operation of a business, as of a slaughterhouse, or a dairy, the discharge of sewage on the plaintiff's land, or the sale of water for purposes of hydraulic mining when the defendant does not know the mining is to be done in a wrongful manner, or the laying of railroad tracks in front of the plaintiff's land. In every case the thing complained of may be done in a manner that will cause no harm to the plaintiff, and the mere fact that it is to be done is no proof that it will be done wrongfully. But if the plaintiff can show that the thing complained of will probably be a nuisance to him, he is entitled to an injunction appropriately framed to protect his right that is threatened. Thus, if a structure is being erected, and the plaintiff can show that it is to be used in such a way as will probably be a nuisance to him, he may have this use enjoined, although he may not be able to enjoin the erection of the structure. While if the structure itself, without regard to any use of it, will cause a nuisance, the injunction will forbid its erection at all. And if this distinction is sometimes disregarded and the structure as well as the wrongful use of it enjoined, it is doubtless because of the fact that the erection will be useless for any other purpose than the wrongful one. Hence a strict limitation of the scope of the injunction is not very closely observed. Thus the courts have enjoined the erection of a privy near plaintiff's house, of a toll gate, and of a powder magazine. So, too, threatened acts which if done would cause a nuisance, as the diversion of water, or discharge of sewage on the plaintiff's land, or the use of an artificial pond as a place for dumping mining debris, have been enjoined. In a majority of the cases of bills to enjoin threatened nuisances, however, the injunction has been refused. The explanation of this is that most nuisances consist in doing in a wrongful manner something which is not wrongful in itself. Hence till it is actually being done in a wrongful way, the plaintiff has so heavy a task in proving the probability of its being so done, that, in general, he cannot meet it. The courts will not grant the injunction simply because it will do no harm to the defendant. 9. Either plaintiff must show clearly that he stands in need of it. 92. Section 1939. Section 525. Must threatened injury be irreparable? On the second branch of the rule quoted above concerning injunctions against threatened nuisances, viz., that the injury must be irreparable, little needs to be said. The significance of it is, of course, that it excludes wholly from the class of cases in which an injunction may be granted against a purely threatened, as distinguished from an existing, nuisance, all those in which the basis of the intervention of equity is solely to prevent a multiplicity of suits. In favor of the rule thus limited, it can be said that there is little, if any, reason for granting relief quietimat with the lack of certainty that any wrong will ever be done which is inherent in such cases, except when there is strong ground for believing that, unless quietimat relief is given, an adequate remedy will be impossible should the anticipated wrong occur. Negatively, the fact that almost all the cases of bills for injunction against threatened nuisances conform to the restricted rule, supports this reasoning. There is, however, some American authority the other way. Section 1940. Section 526. Damage necessary to justify an injunction. The question what amount or character of damage is necessary to sustain an injunction will require only brief treatment, as, in the main, the question, when it arises, is settled by simply applying the rule which is applied on the same point in an action at law. If the injury is irreparable, or such that the damages given by a jury would be conjectural, it is clear, of course, that the question of the extent of damage will not need to be gone into. The class of cases, then, in which it will arise is chiefly, if not exclusively, that in which the reason for coming into equity is to put an end to a permanent or continuing nuisance in order to avoid multiplicity of suits. In this situation the courts generally require no more, but just the same, damage that will sustain an action at law. The result of a careful review of the evidence upon my mind, said the court in a leading American case, is to lead me to the conclusion that the degree of injury is such as to entitle the complainant to damages in an action at law, with the result that he is entitled to an injunction in this court. This is the only logical result of the rule that to prevent multiplicity of suits is ahead of equity jurisdiction. To hold otherwise would be to say that equity will prevent multiplicity of suits only when the damages are according to some standard of the equity courts, and this would be to do away with just so much of the salutary result of the rule as was affected by applying this different standard. It follows equally that in the class of nuisances in which an action at law may be maintained without showing any damages, because a legal right is invaded, as the interference with water rights, or the right to lateral support, or overflowing the plaintiff's land, and the like, that equity should also enjoin on the same showing, and such is the rule. Section 1941. Section 527, Criminal and Statutory Nuisances. The jurisdiction of equity over nuisance is essentially a civil jurisdiction. The plaintiff insisted that it was illegal for Roman Catholics to ring and toll bells in a steeple annexed to their place of worship, said the court in Soltau v. Der held. It appears to me that whether that be so or not, is perfectly immaterial in this case, because, if it be legal, I am not to grant an injunction to restrain an illegal act merely because it is illegal. I could not grant an injunction to restrain a man from smuggling, which is an illegal act. If it be legal, the illegality of it is no ground for my interfering. In accordance with this language, the law is settled that an act will not be enjoined as a nuisance merely because it is criminal, even though prohibited by statutes, whether at the suit of a private person or of the public. The converse of this is not true. Indeed, it is well established that it is no defense to a bill to enjoin that which is a nuisance to show that it is also a crime. If the law were otherwise, public nuisances which at common law are public offences, could never be enjoined. A more difficult question is raised when the legislature makes an act a nuisance which was not such at common law, and provides that it shall be subject to injunction in equity. Is such legislation consistent with the provision of the federal, and most of the state, constitutions that the right of trial by jury shall be preserved inviolate? It is held generally, if not universally, that there is nothing unconstitutional in such statutes. The jury trial guarded by the constitutional provision is that which was required by the principles of the common law. Jurisdiction to enjoin future acts in the nature of nuisances has always been a matter for the equity courts, and as such has never required a jury trial. Hence an enlargement of this jurisdiction does not trench on the requirement for preserving jury trial. If it could be shown that the purpose of the act were to punish or make compensation for past acts in equity without jury trial, the decision might be different. Section 1942, Section 528, the defendant's motive. How far the defendant's motive may be of importance in cases of nuisance is, strictly, a matter of substantive law, and not of the equitable remedy. But, inasmuch as, in a narrow range of cases, the question has, of late years, received considerable attention, largely in applications for injunctions, and as it is likely to arise in the future in similar applications, rather than in actions at law, because the equitable remedy is the only one to afford adequate redress, it may be well briefly to treat of it here. If one draws off percolating water and thus dries up his neighbor's well, or erects a high fence on his own land which shuts off the light from the house of his neighbor, who has no easement of light and air, in both texts, cr. App. 634, 13 An. Cas. 684, 3 liters. R. A. N. S. 622, 90 S. W. 492. Cases acting from a malevolent motive to injure the neighbor, and not otherwise to benefit himself than by causing the injury. Has the neighbor any legal cause for complaint? In this form, and almost exclusively on the above facts, the question has arisen. In cases of percolating water there are dicta from the earliest cases down, that such water cannot be drawn off for the sole and malicious purpose of injuring one's neighbor. The cases in which the courts have actually decided the question have been mainly on application for injunctions, which have been granted. The ground of decision, however, is narrower than the mere impropriety of the defendant's motive. Instead it takes the form of rule of property that one may collect and consume percolating water only for beneficial use on the land on which it is collected. Collection of it for any other purpose may be enjoined by any person affected injuriously. Thus expressed, it is no more drastical imitation of property rights than are all the rules which ordinarily define a nuisance. Indeed, it is doubtful if it goes so far, while the beneficial results to flow from it are obvious. In dealing with the cases of spite fences and similar erections, the courts have made them turn on the malevolent motive of the defendant in erecting the structure. The objections which have been made to such a criterion of legal rights and liabilities have been expressed as follows: to permit a man to cause a certain injurious effect upon the premises of his neighbor by the erection of a structure on his premises if such structure is beneficial or ornamental, and to prohibit him from causing the same effect in case the structure is neither beneficial nor ornamental, but erected from motives of pure malice, is not protecting a legal right, but is controlling his moral conduct. It would seem clear, however, there is neither justice nor expediency in allowing such things as the building of a spite fence to be done, unless the preservation of property rights demands it. It is plain that the right to use one's property for the sole purpose of injuring others is not one of the immediate rights of ownership. It is not a right for the sake of which property is recognized by law, but is only a more or less necessary incident of rights which are established for very different ends. And, however forcible the objections may be to founding relief upon the defendant's immoral motive alone, it seems clear that here the actual interference with the defendant in the use of his property would be less radical than in most cases of nuisance. There he is not allowed to make a use of his premises which is generally beneficial both to himself and to society. Here the use he is making is beneficial to neither and may be equally harmful with recognized nuisances to the plaintiff. As a result of the antagonistic influences that bear on the case in this form, the authorities are divided partly by judicial declaration, but more largely by virtue of statutes. The weight of authority is that structures of the kind under discussion are unlawful and their maintenance may be enjoined. But the malevolent motive must in such cases be the dominant one, such that even if no other were present it would induce the act complained of. It will not do if it is simply present together with other motives which are worthy. Some courts, however, have declined to adopt even this restricted doctrine, and, preferring the hardship of individual cases to a ground of jurisdiction considered to be so fallible as the defendant's immoral motive, have refused relief. It may be permissible to suggest that if the lead of the cases on percolating water were followed, and the decisions based on the reasoning that a man's property right in the passage of light and air over his land is not an absolute right to interfere with it arbitrarily as he chooses, but only for purposes useful and beneficial to him in connection with the land itself, the unfortunate criterion of bad motive would be removed, no harmful restriction of property rights would be created, and the ends of justice would be furthered. Section 1943. Section 529, the balance of injury. The question how far courts of equity, in dealing with cases of admitted or established nuisances, should be influenced, in their determination whether to grant an injunction or to turn the plaintiff over to his remedy at law, by the balance between the injury to the plaintiff from refusing, and to the defendant from granting the injunction, has received considerable attention from the courts, and has met with conflicting answers, often from courts within the same jurisdiction. It is to be noted that the question as here raised excludes certain situations in which its consideration is, beyond all doubt, proper and even necessary. The first of these is on application for temporary injunctions, in which, the questions in dispute being undetermined, the courts must take account of the possibilities of injury in a course of action which the hearing may prove to be the wrong one. The second, is in the determination of the wrongfulness of the defendant's act, the fact of nuisance or no nuisance in that large class of cases in which there is no invasion of a clearly defined right of the plaintiff, such as, say, the right to have water flow in its accustomed channel, but, rather, of a right which is determined by all the circumstances of the case, place, time, degree, and the like. Nuisances such as noise, vibration and pollution of air. In cases of this sort, a balancing of injury, the plaintiff's comfort and enjoyment against the public benefit from the prosecution of the business complained of, the defendant's advantage in carrying on his offending business against the plaintiff's welfare, is, of course, an essential factor in the decision whether any nuisance exists or not. But this point having been determined in the plaintiff's favor, the question now to be discussed is, whether, on an application for a permanent injunction against an admitted or proved nuisance, the courts of equity should carry this balancing of injury admittedly further than the courts of law carry it, and make it a test for the granting or withholding of their peculiar relief. Section 1944. Section 530. Balance between private parties. The balance of injury which may determine the granting or refusing of an injunction rises in two forms, which, however, may appear together in the same ease. In the first of these, the balance is between the injuries to the plaintiff, a private individual, and to another private individual. In the second, between the injuries to the plaintiff, a private individual, and to the public, which benefits from the defendant's wrongful enterprise. On the first of these questions, curiously enough, the same jurisdiction furnishes as strong statements on both sides as may be found in Richard's appeal. An injunction was sought against the use of bituminous coal in the defendant's iron works, which materially injured the plaintiff's dwelling house and his cotton factory. In refusing the injunction, the court said, "An error seems somewhat prevalent in portions, at least, of this Commonwealth in regard to proceedings in equity to restrain the commission of nuisances. It seems to be supposed that, as at law, whenever a case is made out of wrongful acts on the one side and consequent injury on the other, a decree to restrain the act complained of must as certainly follow as a judgment would follow a verdict in a common law court. This is a mistake. It is elementary law that in equity a decree is never of right, as a judgment at law is, but of grace. Hence, the Chancellor will consider whether he would not do a greater injury by enjoining than would result from refusing, and leaving the party to his redress at the hands of a court and jury. If in conscience the former should appear, he will refuse to enjoin. In Evans v. Reading etc. Fertilizing Company, the bill was to enjoin the operation of a fertilizer factory, the stench from which rendered the plaintiff's house almost uninhabitable. After remarking that the proper application of the balance of injury notion was to motions for preliminary injunctions, the court continued, but where, upon final hearing, the mind of the Chancellor is satisfied that the complainant's right is clear, and the injury sustained by him substantial, so that his claim to damages at law is indisputable, and where, moreover, such damages could not give him adequate redress except by an endless repetition of suits, a refusal of an injunction upon the ground that plaintiff cannot suffer as great a loss from the continuance of the nuisance as defendant would from its interdiction, would be as far from equity as can be. There is, to my mind, no more offensive plea than that by which one seeks to justify an act injurious to his neighbor on the ground of its advantage to himself. The court, in another jurisdiction, replying to the argument for a balancing of the injury, said, if the injuries to the plaintiffs were of a trivial character, they should, perhaps, be considered damnum absque injuria, but a comparison of the value of the conflicting rights would be a novel mode of determining their legal superiority. The suggestion of these last two quotations that a balancing of injury is given effect to once in the determination of the fact of nuisance and, hence, does not need to be made a second time in determining the proper remedy, and that it is anomalous to deny the equitable relief in a case where the legal wrong and the inadequacy of the legal remedy are established, is very hard to meet. Denying the injunction puts the hardship on the party in whose favor the legal right exists instead of on the wrongdoer. If relief intermediates between the radical remedy of injunction and the insufficient one of repeated actions at law for damages as they accrue is desirable, it would seem that a legislative provision is necessary to supply it. The weight of authority is against allowing a balancing of injury as a means of determining the propriety of issuing an injunction. Section 1945. Section 531. Balance between the plaintiff and the public. When the defendant's business which constitutes the nuisance complained of is one from which the public benefits directly or in an unusually marked degree, the balance of injury presents itself in a different form. Shall the plaintiff by procuring an injunction put an end to a business from which the public receives large benefit, and from the stopping of which public hardship would ensue? The extreme case which will fully test the rule is that in which the defendant is a quasi-public corporation engaged in supplying a city with water or other necessity. In such a case the nuisance complained of was the smoke from the defendant's waterworks, which, in a material degree, deprived the plaintiffs of the enjoyment of their property. In denying an injunction the court said, if the defendant were enjoined even for a time, the result might be disastrous, for the water supplied by it is the only efficient means of extinguishing conflagrations at the command of the city or its citizens. Besides this, a daily and hourly supply of water used for many purposes would be cut off. We think it may be safely assumed that the rule in equity is, that where the damages can be measured and compensated, equity will not interfere where the public benefit greatly outweighs private and individual inconvenience. On the other side, it has been said by an able chancellor on substantially similar facts, if it should turn out that the company had no right so to manufacture gas as to damage the plaintiff's market garden, I have come to the conclusion, that I cannot enter into any question of how far it might be convenient for the public that the gas manufacture should go on. That might be a good ground for the legislature to declare that the company might make gas if they indemnified the plaintiff, but, unless the company had such a right, I think the present is not a case in which this court can go into the question of convenience or inconvenience, and say where a party is substantially damaged, that he can only be compensated by bringing an action totis quotis. That would be a disgraceful state of their law, and I quite agree with the Vice-Chancellor, in holding that in such a case this court must issue an injunction, whatever may be the consequences with regard to the lighting of the parishes and district which this company supplies with gas. On its merits, as well as on authority, the superiority of this latter view seems hardly to admit of doubt. The refusal of the injunction, in the first place, leaves the plaintiff to suffer an admitted legal wrong and to obtain his only redress by an admittedly inadequate remedy. And, in the second place, so far as the interests of the public are considered, that case is not to be distinguished in principle from the taking of property for public purposes which the federal constitution forbids. True, the damage from a nuisance may not always be a taking as defined by the authorities, but it would seem within the same reasoning, and, if the public need requires it, the plaintiff's property can be taken or legislative provision made for the payment of permanent damages to him. The objection that temporary hardship to the public may result from granting the injunction at once can be obviated by allowing time for the necessary readjustment, before putting it into effect. Section 1946. Section 532. Nuisance easily avoided by the plaintiff. Closely related to the question discussed in the preceding paragraphs is another which is raised when there is offered as a defense to a bill for an injunction against a nuisance, the fact that the plaintiff could prevent the nuisance by a comparatively small outlay of labor or expense. In most of the cases in which the question has arisen, the defense has been rejected, sometimes with vigor. Neither does it make any difference, said the court in Paddock v. Sums, or in any measure operate as an excuse that the nuisance cannot be obviated without great expense, or that the plaintiff himself could obviate the injury at a trifling expense. It is the duty of every person or public body to prevent a nuisance, and the fact that the person injured could, but does not, prevent damages to his property therefrom is no defense either to an action at law or in equity. A party is not bound to expend a dollar, or to do any act to secure for himself the exercise or enjoyment of a legal right of which he is deprived by reason of the wrongful acts of another. In a comparatively early case the same question was raised on the following facts. the plaintiff's spring was overflowed and sediment deposited in it as a result of the working of the defendant's mill. It appeared that the spring could be protected by digging a ditch 250 yards long. On these facts it was clear that a small expenditure of labor would give the plaintiff a protection equal to that of an injunction and at the same time leave the defendant undisturbed in the exercise of his lawful business. Hence the injunction was refused. The unqualified refusal of the injunction may perhaps be open to criticism in that it leaves the plaintiff to incur the risk of recovering from the defendant compensation for whatever labor or expense he should be put to in doing away with the nuisance. But it seems that a very simple and not uncommon exercise of the court's power to mold decrees according to the needs of the case would, in all such cases, meet this criticism and yet save to the defendant the right to continue his business. A decree so framed as to grant the injunction unless the defendant would either himself do the acts necessary to avoid the nuisance or give sufficient undertaking to protect the plaintiff in doing them, and requiring the plaintiff either to allow the defendant to do the acts or to accept the undertaking, as the case might be, on pain of losing all equitable relief, would do full justice to both parties without hardship to either. It must be said, however, that this form of decree has not been adopted by any court in this particular class of cases, although the situation would seem an eminently appropriate one for it. The clear weight of authority is with the first case cited above, granting the injunction unqualifiedly. Section 1947. Section 533, Relief given. Mandatory injunctions. The relief sought in equity against nuisance is, of course, preventive, either to prohibit the creation of a nuisance or to prevent an existing one from continuing in the future. Ordinarily, this end is achieved by a mere prohibitive injunction. When, as is not uncommonly the case, however, the nuisance is one which exists, and will continue to exist, because of acts already done, as, for example, the building of a dam, without further acting on the defendant's part, mere prohibition will not serve to accomplish the desired result. Mandatory relief is necessary to end the wrong. In such a case it was said by the court, it is not to correct a wrong of the past, in the sense of redress for the injury already sustained, but to prevent further injury. The injury consists in the overflow of the lands of the plaintiff. It was not alone the building of the dam that caused the injury, but its maintenance, or continuance, which is a part of the act complained of, and its maintenance can only be stopped so as to prevent its injury by its removal. The removal of the dam, wrongfully constructed, is necessary for and incidentally involved in the preventive redress which the law authorizes. On this ground the use of mandatory injunctions is resorted to whenever necessary to give the full relief to which the plaintiff is entitled. In such cases it is generally destructive acts requiring no supervision that are required, as the removal of an object that is, or causes, a nuisance. Occasionally, however, it may be constructive or continuing acts that are directed. Subject to the reluctance of equity courts to order the doing of acts that will require supervision, it is no distinction between prohibitory and mandatory injunctions or between different kinds of mandatory relief that guides the court in the form of injunction issued, but rather the nature of the relief demanded in order to give the plaintiff the protection to which he is entitled. Section 1948. Section 534. Form of injunction. The forms of injunction used against nuisances illustrate to an unusual degree both the flexibility of equitable procedure and also the relative nature of nuisances. In a great many cases a thing is a nuisance not because it is in itself deemed wrongful in law, but because the manner in which it is done, or the extent to which it is carried, causes it to cross the line beyond which the law will not allow one to go, even in the strict conduct of his own business. This situation is recognized by equity courts in granting injunctions, with the result that they are generally so framed as to prohibit only that part of the thing complained of which is injurious, saving to the defendant the right to continue his business if it can be conducted in a harmless way. Injunctions against carrying on a legitimate and lawful business should go no further than is absolutely necessary to protect the lawful rights of the parties seeking such injunction. When a person is engaged in carrying on such business, he should not be absolutely prohibited from doing so, unless it appears that the carrying on of such business will necessarily produce the injury complained of. If it can be conducted in such a way as not to constitute a nuisance, then it should be permitted to be continued in that manner. This result is sometimes reached by inserting in the prohibition such qualifying words as to the injury or damage of the plaintiff, or others of similar nature, sometimes by giving the defendant leave to apply for a modification of the injunction upon giving satisfactory proof that he can and will conduct his business so as not to amount to a nuisance. Or the court may make a tentative specific order, subject to be modified if experience shows it does not satisfactorily accomplish its purpose. In accordance with the same principle, injunctions will not be issued, it is said, against a business which is a nuisance, when the nuisance can be remedied by the use of scientific appliances. Instead, the court will direct the introduction of such appliances, and whenever necessary to prevent hardship, a reasonable amount of time, in which the defendant may conform to the injunction, will be allowed. Section 1949. Section 535. Temporary injunctions. The granting of a temporary injunction in cases of alleged nuisances does not proceed on different principles from those common to this particular exercise of equity jurisdiction in other cases. Its function is to preserve property until disputed questions concerning it are settled. A plaintiff who moves for such protection must show a prima facie case of right in himself, otherwise he makes no title in himself to relief of any kind. And, further, since the time for which the injunction is sought is limited to the period necessary for deciding the disputed questions, that is, till the judgment at law or the decree in equity, as the case may become, it is clear he must show danger of injury occurring within that interval such that the damage is recoverable at law would not be an adequate remedy, which means, generally, that he must show danger of irreparable injury. It is probably because of this that one may lose his right to a temporary injunction by delay in a shorter time than will bar him from procuring a permanent injunction. By his delay he shows that he himself did not consider his damage so serious as to require emergency protection. For the same reason, the injunction is denied if the defendant denies all intention to do the acts which the plaintiff alleges will constitute the nuisance complained of, though it does not apply if he simply denies that they will amount to a nuisance, that being simply his opinion. It has already been suggested that since temporary injunctions must be granted while the rights of the parties are yet undetermined, and hence, whichever course the court may pursue, a wrong may result, from granting an injunction against a defendant whose defense may prove good, or from refusing it to a plaintiff who may prove to be entitled to it, therefore the courts should take into account, on applications for such injunctions, the balance of injury likely to result from the one or the other of the two courses open, and act accordingly. In the language of a case from which quotation has been made before, so far as the balance of injury notion refers to the parties to the litigation, its legitimate application is to motions for preliminary injunctions, not to final decrees. Where the question before the court is as to the propriety of stopping a business by preliminary injunction upon an ex parte showing, which may or may not be substantiated by further examination of the case in due course, it is very well for the Chancellor to take into account the magnitude of the defendant's investment, and compare it with the character of the plaintiff's alleged injury, and if the latter appears trifling beside that which would result from the impairment of the former, he may well refuse to exercise his power until more fully advised. And although, as has been seen, all the courts do not agree in limiting the application of the doctrine as narrowly as this, yet they are all agreed that its application here is a proper one. It is perhaps nothing more than the effect of this rule that occasions the frequent expressions of caution and reluctance in granting mandatory temporary injunctions to order the removal or destruction of an object which is alleged to be or to cause a nuisance is to compel the defendant generally to lose its value, and whatever labor and expense is necessary to obey the order as well. This is often obviously more than it would be merely to order him not to do something, to refrain, by the injunction. Hence the balance in his favor against granting the injunction is by so much increased. This is apparently what Lord Thurlow had in mind in an early case in which he refused to order a ditch filled up on motion, saying, "I do not like granting these injunctions on motion. The ditch may be a mile long." Yet if the plaintiff's case is strong enough to make the balance of injury favorable to him, The courts have from the time of Lord Thurlow himself granted mandatory temporary injunctions in his behalf. The test for granting or refusing it is the same as for prohibitory injunctions. The difference is in the facts. Section 1950. Section 536. Complete relief. While the only ground for coming into equity in cases of nuisance is the right to an injunction, yet a party who has established this jurisdictional right will be given all the relief, both equitable and legal in nature, to which his case entitles him. The principle on which this is done is the same that always controls the action of courts of equity, viz., to prevent the obvious hardship of compelling a party to seek relief from a single wrong in two suits prosecuted in different courts. Hence, in addition to an injunction, damages for the past nuisance will be awarded. And if, after suit is brought and the jurisdiction in equity is attached, the defendant ceases to commit the nuisance, nonetheless the equity court will give the plaintiff damages and not turn him out of court and compel him to bring another action at law. And it is sometimes held that the injunction also will issue even in this case. Section 1951. Section 537, Estoppel, Acquiescence, Laches. These subjects require no special treatment here, being adequately discussed elsewhere. An important distinction common to all cases in which an injunction is sought in aid of a legal right is well brought out in the following quotation from a case in which the maintenance and operation of an elevated street railroad adjacent to the plaintiff's property was sought to be enjoined. The defendants, failing to establish the bar of the statute of limitations, still insist that the affiliated principle of acquiescence constitutes a defense to the action. There is no foundation in the case for a claim that the plaintiff's conduct amounted to an estoppel, and, indeed, the claim is not seriously urged by the appellants. It is obvious that such conduct has never led the defendants into a line of action which they would not otherwise have pursued, or encouraged them to expend money or make improvements by reason of their reliance upon the alleged inaction or acquiescence of the plaintiff. They inaugurated their enterprise in the face of persistent opposition by the plaintiff and other abutting owners, and carried it to completion while earnest efforts were being made to prevent them. The case is entirely destitute of proof showing the existence of any elements of estoppel, and the defendants are, therefore, driven to rely, in this respect, upon the mere inaction of the plaintiff to prosecute his claim. But this question, we also think, is governed by authority equally conclusive with that relating to the statute of limitations. The doctrine of acquiescence as a defense to an equity action has been generally limited here to those of an equitable nature exclusively, or to cases where the legal right has expired, or the party has lost his right of property by prescription or adverse possession. Whatever may be the rule in other states, it can be said that here no period of inaction merely has been held sufficient to justify a nuisance or trespass, unless it has continued for such length of time as will authorize the presumption of a grant. The principle that so long as the legal right exists the owner is entitled to maintain his action in equity to restrain violations of this right has been uniformly applied in this court. Section 1952. Section 538, Parties. The parties who have a sufficient interest to enjoin a nuisance are, in general, those who sustain legal injury. A landlord may do so if the nuisance is one which will permanently damage the reversion, not if it is one that will not do so, and is likely to terminate before the tenancy ends. A tenant may also procure an injunction even when his tenancy is very brief or shortly to end, though there are intimations that he must join the reversioner as a co-plaintiff. A town has been held entitled to maintain suit against an obstruction of a highway because of its liability to an action for damages by any person injured by the obstruction. On the other hand, a county has been enjoined from allowing a nuisance to continue because the remedy by mandamus was inadequate, and a landowner from permitting a public nuisance to continue on his land, though he did not cause it himself. It has also been held that a grantee of one who has been enjoined from a nuisance connected with the use of the land, is bound by the injunction, though not a party to the suit. That the person committing the nuisance is a tenant, is, of course, no answer to a bill against him, and the lessor may also in such case be enjoined if he threatens to continue the nuisance after the termination of the tenancy. Section 1953. Section 539, Reasonable use not a defense. In this and the two succeeding paragraphs the questions involved are purely legal, having to do with the substantive law of nuisance rather than the equitable remedy. They will require, therefore, no more than a bare statement of the law, with a citation of a few cases in which it has been applied in suits for injunction. It is no defense to an action at law or a bill for an injunction against a nuisance for the defendant to say he is conducting himself reasonably in doing the thing which is complained of. The application of principle governing the jurisdiction of the court in cases of nuisance does not depend on the question whether the defendant is using his own reasonably or otherwise. The real question is, does he injure his neighbor? It is perhaps accurate to say, therefore, that there can be no such thing as a nuisance resulting from reasonable conduct. Nuisance is not based on any rule of negligent or willfully wrongful conduct, but rather on rules of policy which do not allow a person to do those acts which constitute nuisances. If he does so, he is not acting reasonably. Section 1954. Section 540. Nor the fact that other causes contribute. Nor is it a defense that other persons or other causes than the defendant's wrongful acts contribute to the nuisance. If the plaintiff wishes to submit to certain nuisances, that is no reason for allowing the defendant to impose one on him against his will. And if the nuisance results from the combined effect of separate acts of the defendant and others, that also is no defense to a bill for an injunction. Section 1955. Section 541. Legalized nuisances. Acts which at common law are nuisances may be legalized by statute, if such legislation does not amount to the taking or damaging of property forbidden by constitutional provisions. The effect of such statutes is to take away the wrongful character of the acts legalized. They are no longer torts, and hence, the remedy by injunction against them, of course, ceases. Section 1956. Section 542. Public nuisances. Public nuisances, as a subject of equity jurisdiction, require only a brief discussion in this place, because the equitable doctrines applicable are essentially the same as those applied to private nuisances, and cases to support the text of this chapter have been drawn from both classes without distinction. It is on the ground of injury to property that the jurisdiction of this court must rest, and taking it to rest upon that ground, the only distinction which seems to me to exist between cases of public nuisance and private nuisance is this, that in cases of private nuisance the injury is to individual property, and in cases of public nuisance the injury is to the property of mankind. I think, therefore, that the same principle must govern the question as to the interference of the court, whether the case be one of public or of private nuisance. What, then, is the principle by which the court ought to be governed? I take it to be this: whether the extent of the damage and injury be such that the law will not afford an adequate remedy. Here, too, as in cases of private nuisance, the chief causes of inadequacy lie in the fact that the injury is irreparable or will occasion a multiplicity of suits. If there is a substantial dispute as to fact or law, and the question is in doubt, a trial at law will be required before equity will intervene. A purely threatened public nuisance may be enjoined, if it is shown to be imminent and serious. Damage will be required or not according as it is, or is not, necessary to maintain an action at law. All public nuisances are crimes, and so, as before pointed out, the entire jurisdiction of equity over them is a denial of the contention that the mere criminality of an act precludes equitable intervention. Public nuisances may be created by statute, and, conversely, common law public nuisances may be legalized by statute. The balance of injury doctrine is subject to the same differences of holding as in cases of private nuisance. It is generally held that a plaintiff may enjoin a nuisance even though he himself easily could avoid or remove it. The relief given is adjusted to the needs of the particular case. Though usually prohibitive, it may be by mandatory injunction. It will save to the defendant the right to continue the act complained of in a harmless way if such thing is possible. Temporary injunctions are applied here as elsewhere, subject to the general rules governing their use, and complete relief, legal as well as equitable, will be given. Inasmuch as a prescriptive right to commit a nuisance as against the public cannot arise, the public cannot be precluded by laches at all from procuring an injunction. The parties who may enjoin a public nuisance are, first, the public, through the proper public official; second, private parties. While the public which acts is generally the state, Yet by virtue of legislative delegation, often implied, it may be a municipality that files the information. Public nuisances may also be enjoined by private individuals who suffer a special damage,